at the next two meetings as well. I'd also like to thank our committee chair, Nadine, and our consultant, Mike Asimo. And I understand, Mike, that this is the 50th anniversary of the very first project you did for ACUS. So I want to recognize that and thank you for half a century of contributions to helping to make the administrative procedures of the government work better. So thank you very much. Next time we'll when we get together in person, we'll have a cake. I also see, Mike, I have to comment on the fact that I see the piano over your right shoulder there, and I'm looking forward to perhaps a little music at some point. If nothing else, maybe you can play something to encourage speakers to wrap up their remarks and get off the stage. I think we've got a very interesting subject, an excellent report that Mike did, a good draft of the preamble and recommendations to work from. So I'm looking forward to the work we do today and the amendments we consider. So thank you again, and back to Matt.
Thanks, Andy. I will now call two rolls. The first roll will be the names of committee members and their alternates. After each name is called, please say here or present so we can make sure your microphones are working. Nadine.
Here.
Kent.
I'm here.
Jack.
Yes, I'm here.
Ty.
I'm here.
Janice.
Here.
Jeff Lubbers is going to join us in about an hour and a half. David Pang is alternate for Patrick Nagel. Not here quite yet. Roxanne Rothschild. Okay. Channing Strother.
I'm here.
Right. Lou is going to join us at 3. Chris Walker.
I'm here.
And Russ Wheeler may be late. Russ, are you here? No. And Matt Weiner might also be a little late. I see Annika, you're joining us. Thank you so much for being here.
Sure. STV.
All right. Is there any committee member present whose name I did not call? Right. The second roll will be the names of ACUS members who are not on the committee and their alternates. After each name is called, the person should say here so we can know that your mic is working. I'll also call the name of our consultant. I'll start with him, Michael.
I'm here.
And Joe.
Here.
Right, thanks. Thanks for joining us, Joe.
Yep.
Is there any ACUS member present whose name I have not called? Great. Please reach out via the chat function or via email if you experience any technical difficulties during the meeting, and we will try to solve them. I've already been flagged for one problem, and I was unable to solve it, but we'll do our best. And I will hand it over to Nadine to run the meeting. Thanks, everyone.
Thanks. Thanks, Matt. Great to see everybody. I'm going to go through the ground rules. Some of you know them well. For those of you who don't, you're going to hear them either way. Please note that only ACUS members, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges, meaning that a non-ACUS member should write in the chat if you would like to speak. To avoid background noise, please keep your microphone on mute and use either the Zoom's hand raise feature or add a comment in the chat feature if you would like to speak. I can then call on you and you can unmute yourself, say your piece, and then remute yourself when you're done. I would also ask that ACUS members and their designated alternates use the webcam if at all possible. It's helpful for the work of the committee. With respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points, and we will presume that committee members consent to that absent them raising an objection. If any such participant would like to speak, please indicate in the chat feature or use the hand raise feature and wait to speak until I call on you. You can unmute, say your piece, remute when you're done. For all participants, please use the chat function only to indicate when you would like to speak, or for committee members and their alternates to vote when you're asked to. Please do not hold any sidebar discussions or put substantive comments in the chat feature. We want to hear from you. So on the off chance that we get to a vote today, which I don't think we will, but if we do, only members of the adjudication committee have a vote. Please do not vote unless you're a member of the committee. If you're not sure of your status, we can definitely figure that out between myself and Matt. So I am going to turn things over to Michael, Professor Asimo. I just want to say that I am thrilled to be working with him again on a project. My first project as committee chair back in 2016 was with Michael. And so I have fond memories of that work, and clearly it's gone on to do great things. We're all using type A, B, and C as the nomenclature for these adjudications. And I'm very excited to hear what you have to say about the line in your report that caught my eye was that this is true informal adjudication. This is it, type C. So Michael, please tell us a bit about your work.
So thanks, Nadine. Thanks to all of you. This is a pretty awesome committee. I didn't quite realize how many people there were. Many of you I know well, others I don't know, but only by reputation. So I'm thrilled that all of you will be involved in this project. And I especially want to thank Matt Gluth and an intern for ACUS, Hannah Shepard, who were so very helpful to me, especially in conducting interviews, which is it had to be arranged and long and kind of tedious sometimes. So thanks very much for that help, and also to Matt Weiner and Jeremy Grimois, for your wonderful input. So a couple of comments about my report. Of course, all of you today are concerned more with the recommendations for ACUS, but I'm equally concerned with the report, which in its present form is really not quite complete. Footnotes haven't been cleaned up, and there are some agencies that we may drop out that, for various reasons. I hope that you were all able to plow through it, and I'm really appreciative of any comments people can make about the report. It's such an ambitious project, and I'm talking about vast numbers of programs that I don't have any personal familiarity with, but you do. And so comments on that report would really be welcome. They can just be offline to me. So a couple of things to note about the report. Some in part 2, which is the tedious part to read, the description of vast numbers of type C adjudications. I guess perhaps about 20 of them. Some of them are backed up by detailed interviews, and others are not. And just essentially what's available in the in the printed record in the Federal Register about them. So that's a criticism you can make of the report, is that some accounts of these agencies are very detailed and backed up by interviews, and others are not. Just as a matter of resources, we didn't have time to interview everybody from each of these agencies. So comments, Joe, for example, made a very valuable comment about the ombudsman at the SBA. Well, I didn't know about that, but I'll certainly add it to the report. That's very valuable input, and I hope others of you will do the same. I want to mention that in the best practices that we're going to go over today, some of them are in the wrong place. Paragraph 11 under administrative review is actually about notice, and there are a couple of others that are misplaced, which Matt, I know, will clean up. So speaking about, so what's this report about? It's a vast universe, vast. There are countless thousands of Type C adjudications conducted by the federal government. It's an enormous grab bag of programs that actually have very little in common with each other, except they do involve adjudications, binding on somebody, on an individual, sometimes a government, an employee of the government, usually a private party outside the government. So it's extremely ambitious. The stakes involved vary from the most trivial, such as the legendary forest ranger who gives me the last campsite and denies it to you, up to extremely consequential decisions. And that all of them involve adjudications, as I've defined that word, meaning a legally binding result involving an individual against the government, and done without the benefit of an evidentiary hearing. So they have only that in common. One question I'd like you to think about is a large category that I have included, but perhaps should be excluded, and that's what I call land use decisions made by the federal government in response to applications. So the example of that in part 2 is FERC's decision on hydropower projects, but there's many other like that that are much more like rulemaking than adjudication, because they have vast impacts on vast swaths of the economy and on many, many people. And so in that respect are like rulemaking, but they are licensing. They're triggered by an individual application. And they're very procedure heavy, but of course not including evidentiary hearings. So should that be even part of this project is something I'd like you to think about. So we often think of this type of adjudication, that is lacking in evidentiary hearings, as a big black hole that's really procedure free, but that's not the case at all. There is quite a lot of, and it surprised me how much procedural regulation there actually is in sections 555 and 558 of the APA, rarely but sometimes in due process and in FOIA and the Administrative Practice Act, government ethics rules, ombudsman rules. There's a lot of regulation of the procedure of these agencies. And so I've tried to build from that, including what I call consultative due process, to come up with best practices that could be said to be applicable across the board to Type C adjudication. Also building from practices of many agencies, from ACUS recommendations of the past, and so on. That's been sort of the raw material from which I worked to come up with these recommendations. So the approach that's taken here is not statutory amendments, although some of the literature does contain recommendations for across the board statutes. I haven't done that. I don't think that's feasible at all. It would require drawing all kinds of extremely difficult distinctions. But we don't have to worry about those distinctions if we use the best practice route and realize that these best practices are defaults. And agencies can and should depart from them depending on the specific circumstances, such as the stakes involved, and all kinds of other factors that should appropriately be taken into account in designing the procedures for particular Type C adjudications. So that's really essential. Not all of these are applicable, or they're applicable in different ways to all this vast numbers of programs that are covered by this recommendation. And I would say that most of the agencies I studied do already comply with most of these best practices. So, in order to avoid stirring up a lot of agency opposition, we can't be too ambitious, and we really must avoid evidentiary hearing thinking, Type B adjudication thinking. That just doesn't apply when agencies are making these decisions without conducting evidentiary hearings. And I think with that, Nadine, maybe I'll stop and you take it from here.
That's great. Thank you. I thought before we dive in, and I'd like to start with the recommendation, if there were any just general comments about the report, the ideas that we're looking at. I know there were several comments. I want to thank everybody who submitted comments ahead of time. That's always helpful to have that to look at before we dive in. Any just general comments about the report? Great, okay. Matt, I think, oh, Chris, yes.
Yeah, I was curious with Michael, when he was thinking about how he framed the report, and this is more about the report, the recommendations, and was thinking about like the default. I'm kind of curious, Michael, why you didn't gravitate more to Emily Bremer's kind of rediscovered stages, that informal really isn't a mode, it's a stage. And maybe this is a conversation over dinner or something, but that was one thing I was curious, because it kind of does frame the whole report and set of recommendations in ways that maybe are a little counterintuitive to me.
Well, Emily, in her study, a very wonderful study of phases of adjudication, was really speaking of evidentiary hearings. As I recall her study, she's really not talking about this field of informal adjudication where there are no hearings. And she talked about the stages leading up to evidentiary hearings. And of course, those stages look very much like informal adjudication. There's all kinds of negotiations and conferences and all kinds of things like that that are typical of informal adjudication that are also part of formal adjudication, both type A and type B, because the vast majority of type A and type B cases get settled. They don't actually go to hearings. And I tried to recognize that at one point in the report, and maybe it should be emphasized even more. But if there isn't going to be an evidentiary hearing, that's a different ballgame.
Thanks. Jack?
Thanks. My one sort of framing comment or reaction was about something that you, Michael, that you left in footnote 14 of the report, but and it's as follows. When I teach this material, when I conceive of this material, I think of it as framed by the definitions sections in section 551 of the APA, which is what you talk about in that footnote. That is what my basic starting point on this is, that there are only two kinds of final agency actions: rules and orders. And orders are formed by adjudications, which means everything that's not an adjudication covered by 554, 56, and 57 is an informal adjudication. And then I look for any procedures that apply to all such adjudications, and those are in 555. And so I frame it in APA terms. And I'm wondering whether you might want to think about it being useful to move that material in footnote 14 up into the body of the report and provide more of a concrete structure based on the APA, rather than dive right into the type A, type B, and type C, which is an ACUS formulation rather than a statutory formulation. That was sort of one framing reaction I had, which I didn't put in my comments because I wasn't sure if it was really appropriate to do that in this context. But it seems to me to be one thing to consider.
Thanks, Jack. I'll take a look at that. The APA only covers a narrow category of adjudications. There's a vast number of adjudications involving evidentiary hearings not covered by the APA, and I'm trying to the big thing here is to not cover those, and to only cover, they're all orders, they're all adjudications, but the big distinction is between type B and type C, where whether or not an evidentiary hearing is involved. So that's the whole thing, framing device from on which this report turns.
I mean, I hesitate to say anything about adjudication that contradicts you, because you're the expert on adjudications, but I don't consider the APA as not covering these forms of adjudication. I consider it covering it in 555.
Right,
And
that's
with the
true.
right to have counsel if you're summoned to an agency, and the right to have a decision with an explanation, how, brief explanation. And so it's just the division between type B and C is between adjudications with an evidentiary hearings and adjudications without.
Right.
But they're all, in my view, the way I think about it is that they're all actually covered by the APA. There's just a lot less detail when it comes to the type C ones. But anyway,
That's
the way
absolutely
I
fair. Yeah. It's a struggle to deal with framing, because that's absolutely true. The APA 555 and 558 as well do cover these. And I've tried to pick up on that extensively. So, right, I hear you, Jack. I'll think about that. Thank you.
Okay, great. All right. Thank you. Thank you for that. That's helpful to have in mind as we move forward into the recommendation. So why don't we get that up on the screen and hopefully everyone can see it.
This is, if you can blow it up just slightly, just even 1 degree up. Yeah, perfect. Those of us with eye problems.
Thank you, Matt. It's great. Okay, so we had a number of comments, as I said, which is great. And I know Matt did his best to capture those into the document we're going to work with. And so we'll start right at the top, like we always do. The first recommendation. Now, I think, Michael, you had a suggestion here about demarcating these in some way.
Yes. I think it would be helpful, to, for example, in the place where you have your cursor right now, opportunity to submit evidence and argument, that's perhaps that can be referred to as A and BC. So there's whatever there are, about eight of these recommendations, and then these little numbered paragraphs fall under them. But I think it would be helpful to be able to say, well, we're talking about recommendation A here. When we talk about submitting evidence and argument, it's just an organizational, comment.
Okay. Yeah, I think this follows the normal, Matt, I don't know if Matt or Jeremy can weigh in on that in terms of the normal format that we use. I don't know if that's something we could.
This has been the stylistic convention since I joined ACUS, but
Yeah.
Jeremy might be able to speak at more of the historical evolution of this.
I can't speak to the historical evolution, saying this has been the practice since I joined ACUS.
Okay.
But if there's ways to clarify, we can certainly do that. I don't think it's written in stone.
Well, why don't we'll dive right into the first recommendation and we can think about this as we go forward. Were there anything from the group on recommendation 1 here? Okay, that's a good sign. Oh, Matt, you need to change your name. Been there.
Nadine, this is Kent. I
Oh,
may
hi,
have
Ken.
I may have one more. I kept thinking about it. I kept reading the one clause over and over where
Yep.
it says, depending on the stakes involved, as well as agency's caseload and decisional resources. I would think that the type of presentation of evidence would also be a function of the kinds of issues that are often in dispute. So again, if we have something like credibility, I would think we lean towards having some form of perhaps oral informal conference, something along those lines. So I might add something here, like depending on the stakes involved, the common questions involved, as well as the agency's caseload, something along those lines.
Agreed.
Any thoughts on that from the group?
This is Hi. I'm not sure what that means, the common questions involved. I mean, I think number two with the credibility issues, that's a good point. It's not an evidentiary hearing, but certain cases permitted the opportunity. But what does the common questions involved mean?
It might be better to say the types of issues involved. That would be more clear.
Beth, do you have a reaction to that?
No, that makes sense to me. It gets us around the issue of commonality. But how does that deal with your problem or not?
No, yeah. I just literally was, if I were a reader and I went, the types of issues involved, that makes sense.
Okay.
Because they might be more significant or not. Yep.
Works for me.
I know how you're thinking about implementation, which I love. Always thinking about what
Yes.
people are going to see and take away. Yeah.
Exactly. It's good.
Yep. Any other thoughts on one?
So that's right, because most of the issues in these cases are discretionary and policy issues. Credibility issues are relatively rare, but they do come up. But definitely when we're talking about law, policy, discretion, legislative fact, and all that, different procedures should apply. Well, it's a good point.
That's a good segue into recommendation 2 about credibility issues. Anything on 2? Okay, let's move to 3. I think we have some comments on 3. I see some little. Okay. So on 3, we have Jeff and Russell, and I don't think Jeff is with us yet. Let's start with Russell because I know he's on. I think this was basically some.
Oh, just a minor thing, just rather than say
thing.
there is, just say no. I can't tell if he changed it or not.
He did. It says agencies should allow instead of not restrict. I think that was your suggestion, Russell. No?
I don't think so. I think mine was
No?
less consequential than that even. Where it said, I don't know, he seems to incorporate it. Looks fine to me.
Okay. Any reaction to the changes there? Okay, and
Nadine,
then.
this is
Yep,
sorry,
yeah,
this is
yeah,
Kent again.
yeah, yes.
One thing I might add, just so it tracks 555 from Jeff's comment a bit more, is by a lawyer or a qualified lay person. Because they talk about a qualified representative, and as I understand it, I'm no expert on it, but the various programs have things that you have to do and have certain trainings in place to come in as a lay representative.
Thank you. Can we highlight, can you show all of Jeff's, is there a way to just click in it? And I think he has more, yeah. Well, he says this can be handled in the preamble, so, but I guess to the extent we're gonna echo some of this there. Any reaction on adding qualified?
So this is Anika. I agree with that. And I was also thinking, like what I think we had wasn't there an ACUS recommendation in the last couple of years about how agencies should look at sort of non-lawyer practitioners and what rules should be around those kind of people. And so I wonder whether we just want to take a look at that recommendation as well, and make sure, because I think here we're not really talking about changing the whatever regulations an agency has about who can be, who can represent whom if you're not a lawyer. That doesn't seem to be the point of this. I think we're just trying to say that, you should basically have the same rights to representation in type C adjudicative hearings as you would have in other types of, hearings as well. But I don't want us to sort of like inadvertently step into it when we're talking about being represented by people other than lawyers.
Thank you, Jeremy.
Maybe I can pose this question to Michael, because I actually interpret this as that was the point, that agencies in type C proceedings shouldn't unduly restrict who can practice before the agency, especially in fields where the stakes might be low enough where it may not be a good business decision for attorneys to even take these cases.
Well, right, absolutely. I think it should, qualified lay people who know what they're doing. Very common, for example, in veterans benefits cases. But people who are involved in Type C adjudications need all the help they can get. And so if there's lay people who have expertise, agency should encourage that. That's really my point. So the use of the term qualified makes me a little nervous.
It makes you nervous, Michael?
Yeah,
I mean,
because it could create a way for agencies to exclude lay representatives.
did you have a comment on that?
But on the other hand, the IRS, for example, does have a system of qualifying the lay representatives who are permitted to represent taxpayers. So maybe it's okay.
Oh, it's interesting. Now I've commented on both. So on both qualified and then allow as opposed to not restrict. So on qualified, I do think it is important, Jeff's point of, he was just picking up a other duly qualified representative. Based on Michael's piece, I wonder if we don't put in qualified, but picking up on Anika's point, in the preamble, we say that if they're represented by a lay person, then the general rules of that agency about what qualifications you need to have generally to represent someone if you're a lay person can be found in, and then you note the recommendation we have. Again, thinking implementation, we want agencies to know we actually have a lot of guidance for you on how to decide whether someone is qualified. So I think based on that, even though initially I like Jeff's point, I would not put in qualified, but I would put something in the preamble making that point. And I'll make my second point and then people can respond to both. I have to say, I sort of liked initially reading agencies should allow. I mean, that's so much more straightforward than agencies should not restrict. But I really am curious, Michael, from you maybe and others, that were you actually trying to get to something different by saying you should not restrict versus saying you should allow?
That was not my language at all. So I definitely think we should say allow.
Okay, good, because that's my instinct, but okay.
Jeremy, did you have something on this point?
Oh,
Just one word of caution in citing the earlier recommendations, 2021-9 might be worth taking a look at. It's pretty modest. It basically says that agencies should have rules governing the conduct of representatives, but doesn't say too much about when you should, for example, allow non-attorney representatives. So if the intent here is to actually affirmatively say agencies should not impose unduly burdensome qualifications that might restrict non-lawyer practice, I don't know that the earlier recommendation goes quite that far.
No, but I appreciate Anika flagging it for us to look at. That was good memory. Jack and then Ken.
I was wondering whether a lot of this fighting that we're having about whether it should be qualified or not is taken.
We're not fighting.
Not fighting, disagreement or discussion is taken care of by recommendation 4, and whether recommendation 4 were clarified to say something about including, aiding and making a presentation. Then you have sort of on the one hand people being represented. That was the incomplete language, but there's a difference between being represented by someone and being aided in making their presentation to the agency, and maybe that's where we're getting stuck, because I think there's somewhat of a tradition of having either lawyers or some qualification before you can actually represent someone, versus helping someone speak. I mean, I've been at a trial where it was a corporation that it was an individual who couldn't be represented by someone else who wasn't a lawyer, who had no idea what was going on because it was part of a family business, and it's painful, you know. So maybe maybe that could help take care of some of this.
Yeah.
Wherever we have some reference to this, whether it's in the preamble or not, just one other reference aside from the recommendation that we discussed earlier. We did discuss this in regard to type A and B adjudications in the model adjudication rules that we did earlier, and it's rule 140. If we thought it was helpful to add a reference, just even in a footnote to it, and there we did similar to what people are suggesting here. We left it open-ended, but it is an actual provision in the rule that the agency is to state what is required of an authorized representative.
That's great. Thank you. So glad people remember these. Thank you, Kent. Okay, so I think we're good on 3. We're leaving qualified out with the assumption that we're going to kind of build that into the preamble, and then we have some language that Jack is suggesting. I know he said it's not quite perfected language. I think that's what you said, Jack, on 4. So let's move to 4. Is there a way to capture? I mean, maybe Jack has done it without even realizing he did.
Well, I think I said including aiding in making a presentation, but that was just really, that wasn't really any sort of final language. Something like including assistance in presenting their case, or, you know, to the agency.
Okay.
Something like that.
Yep.
I mean, does that capture the spirit of what was you know, behind that? Because otherwise, you know, if it's not during the actual presentation, I don't know how the agency would know if someone else gave someone advice at home about how to do something.
Jack, that's really good point.
Well, a lot of it is paperwork. You know, there's many of these involve extensive application processes and stuff like that. So help in dealing with all the you know, the red tape that's involved in these proceedings is very helpful.
I think this language is helpful to kind of hit on the point that Jack's raised. So any reaction otherwise to that? Okay. Can we move to 5? I think there's a comment yeah, this is from Jeff. And I think this would be a question for Michael in terms of, or possibly Matt. So whether this language is really referencing an ombuds. I wasn't sure that we were there, but
no, I like it.
It's
good. It's really not different from the ombuds. The ombuds is somebody you complain to. But some agencies do have these offices that are designed, you know, kind of like public defenders to assist people, and that's very helpful. So using, you know, just as an example here, I think it's good.
Yeah, that's the way I read it, and I would hope all agencies have some level of people, whether it's an office or person, to help the public navigate their process. It's really important. All right, anything else on 5? Okay, let's go to impartiality. And I think this is maybe the area where, I don't know if Michael, you want to just say a few words here before we dive in, but we've got a comment from Matt, and I think Russell has some language concerns, but Matt is raising the prior recommendation that this group did on recusal with Professor Varelli, if I remember right, and how we want to think about impartiality in this context. Michael, do you want to say it?
Yeah, so it's a sensitive question because we do want to certainly say something about impartiality, but we can't import the norms from evidentiary hearings, which, for example, prejudgment of issues. Say when you apply for a visa and a consular official investigates your claim and says no. So he's both the investigator and the decision maker. And that, you don't have that in in an evidentiary hearing. So you have to be careful in how you deal with impartiality. But I think 6 is fine.
Yeah,
I like the idea of using recusal maybe instead of disqualification. Well, that's a good idea.
Any reactions to that? I just had a general sense of, I know there's some language and I'm jumping into, I think the report uses the same language that's in the preamble, which is that we want the public to, that these proceedings should be, these adjudications should be fair and perceived to be fair. And so how do we accomplish that? And I think there has to be some element of this here. And it's just a question of how far, I think, as Michael said, do we go? So any reaction on 6? I think, Russell, you had some language here.
Well, I wondered, I know I just asked the question, the phrase that are inquisitorial rather than adversarial, is that an essential clause or a non-essential clause? In other words, do they not have to be applied to adjudication systems that are not inquisitorial? I think what you want is systems, which. But I may be out of my depth here.
No, I think Russell's point is good, and we can remove that language entirely.
Okay.
Because some Social Security is actually inquisitorial rather than adversarial on its type A. So I think actually that language, which are inquisitorial rather than adversarial, should come out. Not necessary.
Hi.
Actually, well, I think it would still be relevant if you use inquisitorial. I was like sort of taken aback by the word inquisitorial, maybe because of, some of the background to that. And again, I'm just thinking about someone reading this who isn't steeped in this, that even if it makes sense to use the word inquisitorial, that again, in the preamble, I don't think I saw this. Just to make it clear, even in an example that you just used, there are some where they're just trying to collect information. I mean, I would still take it out. I'm not, but somewhere to explain what inquisitorial means, as opposed to getting
rather than have to do that, I think it's better to take it out.
Oh, no. But in case you use it anywhere else, that's why I said, first I said, oh, this isn't relevant anymore. But do you use the phrase, the adjective inquisitorial anywhere else in this? Because if you don't, then no problem.
I don't recall, but
okay, then let's just hold to see if it's used anywhere
I
else.
was completely correct about that. It's very distracting.
Yeah. Okay. I was like, oh my God, we're putting you and gonna ask you these questions in these dramatic way.
So now we still have the which, and we took out the and.
Yeah, just type C adjudication systems that may be conducted.
Wasn't sure if Russell's changed from
Take
that.
out the comma, right? Okay.
Yes, yeah.
Leave in the that.
Yeah, as short, right, as revised.
Okay. Any other reactions on 6? Okay, let's go to 7. I know there's some language here not from Russell, but maybe maybe not. Agency regulations should require. Oh, Anika, I'm sorry. I see your hand up. Is it on 6 or 7?
It's on 7.
Great.
I'm
Go.
just wondering whether OGE is going to have an issue with number 7 if we don't sort of mention, because I think most regulations that look like this are viewed as supplemental ethics regulations, and you have to work with OGE in order to promulgate them. So like, I don't know that an agency could just, maybe they could, maybe this is general enough, but I worry that an agency couldn't just promulgate this without working with OGE.
Well, that's a good point. That's right. That anything that goes beyond OGE's existing regulations, which all involve financial conflicts of interest, they do have to approve them.
Jeremy, did you have a comment directly on that point before I
Yeah,
go to
it's a great question. I actually reached out to our member from OGE shortly before this meeting, so I have not heard back yet, but I think it's a great point, and I will share that information with the committee once I have it.
I seem to recall some of this with the recusal.
Exactly. We tried to craft this in a way that was consistent with the earlier recusal, but this is obviously a complicated area. OGE has lots of guides to this area. So once I have a response back, I'll share that with the committee.
Great. Thank you. Thank you, Anika. Hi.
I had a short thing, which is why I raised my hand, which is, Matthew, you still have high characterized decision makers in preamble. You should delete that so you're not confused about it, since we said we didn't need that. And then all I would say here, again, in terms of the OGE, absolutely good point. I don't think you'll see, I don't think you're going to need to say in the recommendation, oh, and remember to talk to your OGE folks, because that will be the case. But again, if you're thinking about a document that goes along with this, with bullet points, obviously, like under here to say, and obviously we assume you're going to, in most cases, need to involve your OGE, something like that, as opposed to us in the recommendation to say, and make sure to talk to your OGE. But in any event, obviously, as you said, Jeremy, you'll get the reaction of the person, but I hope as we think about these issues, we think about what should be in the recommendation and what should be in our communication to the agency of, well, and of course you're going to do this because that's your background norm.
Thank you. So Jeremy, Kent, we'll go to Kent and then I'll ask Jeremy my question. Go ahead, Kent.
Oh, sure. This is really minor, maybe even a little pedantic, but in that second line, I think I would make it a bit more concise and just say have a financial interest in particular matters, because I'm not sure exactly what a financial conflict of interest is versus a financial interest that isn't a conflict.
Good point.
Thank you. Jeremy, my question is, should we, I guess we can continue to look at these, but it may change drastically depending on what you hear back from. Is it David? Did you reach out to David?
I did. Yeah. Hopefully not drastically.
Okay.
So I'll leave it up to you whether you want to plow ahead or not.
Well, we can, okay. Let's plow ahead and we'll just see what we get from OGE. Maybe it'll be very light touch. So anything further, let's look at 7, and I guess if we're done with 7, which I think we may be, we'll go to 8, which goes to partiality. And I'm trying to see if we had any. This is from Jeff. Let's see. Jack would add reasonably. Any reaction to that? I feel like we've covered some of this in that prior recommendation where we looked closely at the process by which a party or an applicant, I guess in this case could be an applicant, could raise the concern, or who's raising the concern? Is it the stakeholder? Is it the agency? Is it the person themselves? Hi.
I just want to say, I think this is a really good addition. I understand reasonably, obviously the agency needs to decide whether it's reasonable or not, but, if we're saying now, agency regulations should require disqualification. Okay, so that's a should. Then I think you need to give agencies the flexibility of employees whom stakeholders may reasonably view as partial. So I just want to speak in favor of adding that word.
Any other reaction?
I mean, this is,
Oh,
this,
yeah,
you
go
know,
ahead, Mike.
this, I mean, I think this is appropriate, and it comes from the regulations, of the Office of Government Ethics. And they strictly regulate financial conflicts of interest, but then there's an aspirational standard that the deciding employee should be impartial. So that's what I was trying to preserve here, and I think it's a good idea.
Okay. Any other reactions to 8 as on the screen? Okay, let's move to, oh, Ken, yes, yes.
Sorry, I keep kind of showing
No,
up a
it's
little
fine.
late to each thing.
It's totally
I'm
fine.
just kind of thinking through them. Michael, I was wondering if you could say a little more about why you want to take out the indication of prejudgment of facts at issue. I understand the point you're making about how the investigators may also be the adjudicators. And I understand how there may be quite a bit of prejudgment in some of the policy decisions that are made. But if this investigator is confronted with additional evidence, which we've said in the earlier portion of this recommendation that the agency should have a process for, I don't think it would be problematic to say that the investigator should stand down if the investigator isn't in the position to take account of that evidence that comes to them that may change their mind as to what the conclusion of the factual finding should be.
So the question of prejudgment is kind of hard to deal with. But when the investigator is also the adjudicator, I mean, the investigator has prejudged the matter while investigating. So, I mean, just taking the visa example, for example, you know, when you apply for a visa to enter the United States, and a consular official looks at the application and looks at all of his sources of information about you and says no, well, you can say that he has prejudged the matter. So I was trying to avoid that type of problem. You really have investigators who are also adjudicators in type C adjudication, very, very commonly. And we have to kind of live with that. Yes, you should have an opportunity to change the person's mind, but as a result of his investigation, he has prejudged it. So that I try to stay away from prejudgment here as a standard. I think that's going to arouse a lot of opposition in agencies that do this kind of work.
I might define prejudgment differently. I would think of prejudgment as being something akin to a standard of an inalterably closed mind, not that you have passed consideration over a certain set of facts before an ultimate conclusion. I would think what you're describing is something more similar to what we see in some of the adjudicatory cases where the court has talked about having something akin to a probable cause determination earlier on, where you've taken in the facts that are available to you, you've made a decision, but that doesn't mean that you've prejudged the matter if your mind is still open to receiving other evidence, as opposed to saying, I'm done and nothing will persuade me otherwise.
So I get that, Kent, and I think it's really already covered by language in 8 as to reasonably viewed as partial. But I'm really, many of these involve exercises of discretion where it's very likely that the person exercising the discretion has prejudged how that discretion should be exercised. I think it's really a red flag to agencies exercising lots of different kinds of C adjudication. So I really tried to avoid prejudgment and instead stuck with this aspirational standard of whether somebody would reasonably view you as partial.
I'll go to Jack. I just wondered if there was any language, Kent, that might capture, I don't know, it's kind of a middle ground. I don't know if that's possible, but I'll go to Jack. Maybe he has an idea.
I was thinking of something along the line of, and the extent and nature of the employer's prior involvement in the matter.
Well, the employee is
extent
always
and
has
nature of
prior
the
involvement in
employee.
the matter, you know?
No, but what I mean there,
He's investigated it, and then he said, no, my investigation has led me to believe you shouldn't get it.
no, I guess what I'm getting at is a more flexible standard than what was originally in there, because I 100% agree with you that if it's the employee who made the tentative or initial decision, that shouldn't disqualify them from making the final decision in these kinds of matters. But there may be factors not captured by personal interest and relationship with the parties that have to do with the way that the whole thing played out that the agency might wish to consider in deciding on disqualification. And I just, I mean, maybe it's just, maybe there should be no other consideration than those two, but, maybe any other consideration that the agency might, might find relevant to whether the standard of impartiality is met. Something like that. That's all I'm trying to capture.
So it would say the agency should consider factors, and obviously we're just trying to give examples here. An agency could consider other factors. And we're trying to give, I guess we always aim with these hints we like to drop, like what do we think is important? What do we think is relevant? Are you saying, Jack, you would get rid of personal interest in a decision and just go with extent and nature?
No. I would leave
No, you would
personal
keep it.
interest in.
Okay.
And
Okay.
but I agree with Michael to get rid of the idea of prior prejudgment of fact, because that's
Okay.
inconsistent with the model of it. I'm just trying to broaden it beyond
Right.
personal interest in a decision, so that the agency, that doesn't seem like we're recommending that be the only or
The only,
basis for
Uh,
the agency's consideration. So maybe either, would you feel more comfortable, Michael, with the language you just said, or any other factor that the agency finds relevant to the agency finds might give rise to a reasonable view of that the employee is not impartial?
Yeah, I like that better.
Okay, that's fine then. By the way, I like the formulation not impartial better than partial, just because it's a clearer and it's a more traditional way of talking
Yeah.
about it. I understand you don't like to give a double negative, but here I think
Yeah,
the double
I
negative
agree.
is better language.
Not impartial is better.
Not impartial is better than partial. Because partial also has a meaning of, like not quite whole.
Hi.
Yeah, I was about to lower my hand because I just wanted to speak against the employee's involvement or whatever, which I just thought was not clear, but I'd like it. Any other factor agency finds might give rise to, I think you had the reasonable view, right, to the view. Maybe you had reasonable somewhere else, someone.
Yeah, it was,
Reasonable view doesn't sound right. Might give rise to.
Was in the reasonably is in the first line of line 96 was added there. May reasonably view.
Yes, no, we did that there, which I said was
right.
good. And then in determining whether disqualification is warranted, the agency should consider factors such as personal interest in a decision and any other factor the agency finds might give rise to the view, I think you needed that, might give rise to the view that an employee is not impartial. Okay.
It's fine.
That's good.
And it's raising a question for me that we want to stick with just employees and not decision maker. We may be talking about more than just the decision maker here. In 6, we're talking about decision makers. Anything, Michael, on that? Like,
that's a good point.
Are we
both
looking
in
at,
says 7 and an 8? Yeah, I mean, we are talking about decision makers. Well, maybe we should say that instead of employees engaged in the adjudicatory process.
I just wasn't sure if we wanted to reach beyond, the decision maker only. Obviously, there are decision maker adjacent employees here in this process. And so maybe it would either be changing 7 and 8 or changing 6 to. Now I guess we have to leave decision maker there because it's engaging in their own investigations.
Yeah, no, maybe it's better to say employees engaged because there's in some of these, like in those big land use decisions, there's so many people involved in all kinds of different
It's
roles.
beyond. Okay.
And I think it would be okay, to disqualify some of them as well. If it turns out, that this has been their worst enemy since high school. Cases that you get like that.
Oh my goodness.
So I think it's okay to say employees engaged in the adjudication.
Okay, great. Kat?
Not to prolong this, but now that we've made that change in the second sentence to add the language that Jack proffered, what work is the second sentence really doing other than identifying personal interest as one of the possible factors that the agency could consider? Do we need this second sentence? Because I think my concern earlier with Michael's suggestion was it was limiting those grounds that could be seen as a reasonable view for impugning upon impartiality. And I didn't want to do that if I felt like it was already sitting in the case law as appropriate grounds. I think that first sentence just leaves it all open now to say any ground upon which one would find the reasonable appearance of impartiality is sufficient.
Yeah, I'm good with that. Good point, Kim.
Yeah, no, I see your point, Kent, that you could end the sentence after personal interest in a decision. You just give one factor. The rest of it is very open-ended, which is not necessarily a bad thing, but I don't know how, from an implementation standpoint, what guidance is it giving?
Yeah, exactly. I think just, you could theoretically not have, and I think, Kent, this is your point, the second sentence at all, right? The regulations should require disqualification of employees whom stakeholders may reasonably view, and certainly a personal interest in a decision is something that would rise that reasonable view. But I actually think for implementation purposes, that second sentence, if it just ends after personal interest, is fine. It's just giving you an example of something that would be a reasonable view. So ending it there, but keeping the second sentence, I think works.
Renee. Hello, Renee.
Hello. Of course, I couldn't find the unmute button.
That's fine.
I apologize for being late. So I was just going to make the opposite point of saying, in determining whether disqualification is warranted, the agency should consider any factor the agency finds might give rise, just to keep it vague and open-ended. But, I'm fine with the example as well. And I just also want to say, to add humor to the conversation, I just attended my high school reunion last weekend. So that reference had particular appeal for me. No one is an enemy of anyone anymore, I will say.
Past history, right? It's all in the past. All right. Any reaction to going with just the one factor as an example? I think that's what's on the table.
So this is Anika. I prefer the formulation that Renee just gave, because I think this whole number 8 is basically all about appearances, right? Which agencies I think about all the time and can vary depending on like the type of case that it is or the type of industry that's being regulated. And I think sort of making it more general rather than giving a specific example will, I think as an agency person, I would understand if someone was telling me, look at appearance issues very closely. I think I would react to that more favorably than something that talks about the personal interest in a decision, which seems like very, I don't know, very specific and just like one thing. There are a lot of other things that could raise appearance issues, such as like, for example, like prior employment that doesn't reach the OGE level to require qualification in a matter, but nonetheless, an agency might want to think very carefully about, who the decision maker is, if that decision maker worked for, a party like 10 years ago or worked in a particular, you know what I mean? Like, and those are going to be very specific to each agency. So I personally think that it should be more general rather than less.
Any reaction to that? I have to say my first thought was to then put the comma after impartial and give the example. But I mean, I hear what we're trying to get at, those issues that, what they call a Washington Post test, right? Something that's going to really make somebody question the fairness of the proceeding. Which is, I mean, I did think that the relationship with the parties, if there's a personal connection or some kind of personal interest, but any thought, I'm going to call on high. I don't like to do this, but in terms of an implementation standpoint, like, does that give you any pain to leave it really broad that way and not have an example?
No, that doesn't,
Okay.
here's an, except I do have a problem with might give rise to the view without saying might give rise to the reasonable view, it's, and again, you realize that basically, this was sort of Ken's point, basically, the second sentence is saying the first thing as the first sentence, but just saying any factor, right?
I think you're good with just the first sentence.
I think you're probably good with the first sentence, exactly. And then you can give some examples in like the FAQs, you know what I mean? You don't have to put examples in the preamble, but you can put some examples in the FAQs. I don't know about the high school reunion, but something. Yeah, that's
Any
better.
reaction to that? The first sentence is really doing the work here. Which is, I think, where Ken started, right? Any reaction? Okay, let's go to 9.
So here we definitely want to take out that language about inquisitorial. You don't need it. Where type C adjudication could involve serious sanctions is fine.
Is it limitations or limitation? Sorry, I'm reading that. Adoption of. No, maybe it's limitation. Committee on style, never mind. Anything else on 9? Kent?
Minor question. Is there a reason to limit the limitation on ex parte communication to outside ex parte communication? I could imagine it depends what the nature of the sanction is and the grounds for the sanction as to whether or not we want internal or external ex parte communications. Of course, the APA permits internal communications for certain kinds of decision makings and decision makers, but not all of them, including for an ALJ typically. So I just wonder if it's better to leave that a little more general.
I agree. I mean, these serious sanctions don't arise that often in type C adjudication, but one place where they do is in national security and economic sanctions and things of that sort, which is type C adjudication. And I don't have a problem with just saying internal separation of functions and limitation on ex parte communications. You probably don't need the word outside.
Anything further on 9? Okay, let's go to the next section. So we have 10, I think Jack had to leave. So I see he's offered a complete kind of rewrite of this one. Any thoughts on this? I'll give you time to read it. Does it capture, I think Jack's point is that it captures the everything in those 3 sentences into one.
I'm good with it.
Any other reaction? Give you time to. Okay. So this is the section where I think both Michael and Jeff raised some concerns about whether this should be considered notice.
Right, yeah, this paragraph 11 is in the wrong place. This is, it's administrative review is just paragraph 12. Paragraph 11 is a broad statement about, about notice. It's not about administrative review.
And then I think Jeff is saying that another recommendation, 18, should be brought up under the notice heading.
That's right.
Yeah. Jeff is not on yet, I don't think. I think he was joining us late today.
So maybe we can just jump to 12 right here.
We can put in notice as a placeholder here, and then
Okay.
let's look at 12. Anything on 12?
Maybe it should be like further down. Notice should come before administrative review.
Right. So we can, let's look at 11. Let's start with 11. We'll go in order. Anything on 11? Let's talk about the change in heading, if there's any concerns about that, and the language of 11. Okay, no reaction on that. Should we look at 18?
Yes.
Quickly and see? I have it on paper in front of me, but.
Right. This should be the other paragraph on notice.
Renee, you have thoughts here?
Yeah, no, on 11, if we could go back to 11.
Absolutely.
What about, I had a question about that word, insufficient time and detail to enable them to challenge that decision. Do we want object? Object, because if it's not,
Renee's right. We don't need the word mount. It's just is needed to allow the participant to challenge the decision.
Well, do we know? I'm debating the word challenge. I wanted to change that to object to that decision, because it's not really. I don't know. I feel like challenge comes at the end when there's a final decision as opposed to this like, you know, intermediate stage when you're kind of still negotiating a bit. But if no one else agrees, that's fine.
Because it's a preliminary decision. You're thinking of
That's
challenge
right.
as
Right.
final. Hmm. If we leave that as object, do we need to then change challenge in 116, line 116?
Yeah,
Not sure about mount, but go ahead. Hi.
right.
Thoughts
Yeah,
on that?
it's so interesting, Renee, because my first instinct was, oh yeah, that's right. Let's keep challenge to, you know, the final. But looking at it again, object just sounds like I object. As opposed to challenge is, no, I'm telling you why this is wrong. So I'm sort of feeling that even though challenge, I mean, it's not like it's required, the challenge is
Right.
and then, you know, because again, to mount an effective objection, in a way, challenge is better. So even though I
Right.
initially, I actually think challenge is probably better in terms of what we're trying to capture.
Yeah, that's fine. I just thought, yeah, I see what you're saying.
Anything further on 11? Anika?
So in 11, we refer to in line 113 now, the agency's preliminary decision. And then later in 12, we talk about initial decisions. And I think we're talking about the same thing there. But there's a difference between a preliminary decision and initial. Like an initial decision sort of stands unless, you know, someone challenges it and it changes, whereas a preliminary decision, at least to me, suggests that it's something that's not you know, that the agency is going to take another step no matter what. And so I just want to be consistent. I think we really mean initial decision in line 113, but I'm not I want to make sure that
No, they're not the same. The 12 is assumes there's been initial and preliminary aren't the same. Maybe they're not the best words.
So are you referring to different things
Yeah,
in
so
11 and 12?
Different phases?
Yes,
Different phases?
yes,
Okay.
yes, yeah. 12 is about here's the agency's decision. The decision maker has made his decision. Now there should be a second shot. There should be an ability to go to a higher level of the agency and ask them for a second look. That's what 12 is about.
So you would
11
imagine
is just the whatever the administrative process is here. You want to give people enough notice so they can challenge it.
okay, so you would imagine that in these type C adjudications, there would be both a preliminary decision and an initial decision?
Yeah, maybe we should
What if you
not
take
use
out
the words
initial?
preliminary decision in 11. The agency.
What
So
about
here's-
proposed decision?
Yeah, something like that.
Hmm.
I guess I just wonder whether there is such a, you know, that two.
I mean, I use the term a frontline decision,
Hmm.
but you know, I'm gonna.
I proposed. That's just me.
Yeah.
Hi.
Yeah, I think proposed is good.
Yeah, and here's my only question, especially as you started, Michael, how many of these adjudications there are. Do agencies sometimes or always let folks know about their proposed decision, or what we're saying in terms of our best practice is sort of no matter how minor the decision is, we're saying there should be something called a proposed decision. And you should give notice to folks of that. I mean, I don't know all the adjudications that you looked at, but are we actually saying something different here? Like, you may not have chosen to do proposed decisions before, and we're telling you best practices, no matter how many of these you do.
Yeah, you're right. I mean, somehow there's, that if you apply for something and an agency is proposing to reject your application, they need to give you notice of why, so that you can take advantage of your opportunity to protest it. So I always use the term frontline decision to refer to what we're talking about here. I don't know if that term is so unfamiliar that it will just confuse people.
Exactly. People will not know. But did you find that there were any number of cases where agencies just, here's the decision, you don't like it, you can appeal it, which is what 12 is. I just can see agencies saying, you've got to be kidding.
I'm not doing this step. Jeremy, do you have a fix or a thought here?
Sort of a question for you, Michael. Are you basically saying that in 11, I should be able to go to the adjudicator and say, hey, can you reconsider this? And 12 is, I can actually ask somebody else in the agency to review the first adjudicator's decision. So 11 might be a proposed decision type process. It might be just a simple request for reconsideration. Like, is that what you're getting at?
No, the 12 really is a distinct idea.
No. I know that. I'm asking about 11. Like, are you really talking about
just
decision?
These processes all vary.
Right. So I was wondering, like, lots of agencies have a request for reconsideration process, which is.
Yeah, I wasn't even thinking about that.
Okay.
This 11 is just about, at some point they got to tell you what they're going to do so you can object.
But Michael, are you saying at some point in every single type of type C adjudication, you want them to tell the person so that they can challenge it, object, give more information? Or are you trying to limit it?
Is that a common feature of these types of adjudications? Or I guess as Hei's saying is, are we telling agencies it should be if it's not?
In the earlier recommendation, we said you should have an opportunity to object, to make your arguments. And this, if you're going to have an opportunity to make an argument to the decision maker, you need some notice in advance of what the decision maker is going to do, so you can protest.
But you know what? I'm just thinking it's like just back to type B, right? Again, I'm coming from EEOC. You're before your hearing officer, judge, you don't find out what that judge is going to say until you get the decision. No one says, here's how I'm planning to rule. If you don't like it, appeal to the commission. So.
Well, you've earlier received notice that they plan to fire you.
No. What's happened is you've been fired. And now you are saying you were discriminated against, or, you've been denied something. So you go, you have your hearing. Now, again, that's type B. It's definitely evidentiary hearing. But in an evidentiary hearing, you don't, at least in that one, you don't get ahead of time, heads up, here's I'm going to decide, let me know if you want to challenge it.
But you got fired. That gave you notice that you had a problem.
That's right. So you're saying here, so it's so interesting though. And again, so much more about all the types of type C adjudications that are out there. So for example, are you saying, didn't you say Social Security determinations were type C? Right?
Well, Social Security is type A.
It's type A, of course.
But here you apply for Social Security and they say no.
Correct. And then,
And they
you
say,
know,
they tell you why they're saying no, and then you can
right,
frame your challenge. In that case, it's before an ALJ.
right.
But, something happens in the case of an application, so you know you're not going to get it. Or if it's a sanction, somebody tells you, we're really proposing to deny your visa, we're proposing to embargo your goods. And that's notice. I mean, I think in dealing with notice, we probably should take up 18 also, which gives what needs to be in the notice.
Look, as a matter of fairness, I'm all about that. Hey, before we deny you this license, you haven't had a chance of an evidentiary hearing. So we're going to let you know we are about to deny this license. If there's anything else you want to send us, let us know. So
That's right.
as a policy matter, as a policy thing of fairness, that makes sense. Again, in terms of response from agencies, if this is really a policy statement, you know what? You should always let people know about the proposed decision. Because as you said, above we said they should have the ability to challenge. I think it works for me in terms of fairness, but we just need to be very cognizant of, is this going to be a big change? And if so, we need to be able to justify it.
I think the recommendation assumes that there's going to be notice, and it's just setting out that it needs to be done within a sufficient amount of time to allow them to challenge it, right? Kent?
I take High's point about whether you'd get pushback on this, and I suspect you would if the argument is anytime you decide something in a type C, you essentially are, to use Jeremy's phrase, requiring that there be some form of reconsideration. And we've got to open our file to you now. We've got to do all of it at this step, even if there is a later evidentiary hearing, whether it's type B or type C. So it strikes me as due process requires that you have some notice and opportunity to be heard, but it doesn't require that it happen at the type C phase or at a type B phase necessarily. It's just you get it somewhere in there. And I do wonder if we're requiring too much of the agencies by suggesting in 11 and 12 that there are two different stages of this notice and opportunity to be heard that are required, when I don't think that's true as a due process matter. And I don't think pragmatically it's true. But like Hai said, I defer to Michael because he knows so much more about the type C adjudications. But I wonder, Michael, does it get at what you are trying to get at by just saying, at some point, there needs to be the ability to challenge the agency's decision at the type C setting and have access to the information that the agency had so that you can mount that challenge to the agency's determination?
Right. We've already said in an earlier recommendation that you need to have an ability to present evidence and arguments somehow. And in order to do so, you need to find out what it is that you're going to object to. But 12 is a really different idea. 12 assumes there's a two-level decision-making process, that you can go to a higher level of the agency and get a second look.
And for that second look,
that's quite different than notice in enough time to make your evidence and argument to the initial decision maker.
that second look for you, could that be just an additional type C adjudication, another step in that process, or it could be a type B or a type A?
No, not type, no evidentiary hearing at all. So, Kent, you applied for a visa. I'm going to look at your application and you need to have an opportunity to tell me why you need that visa or why you should get it, but I say no. But in that process, there is then an ability to go to the counsel or official superior officer and get a second look. It's the idea of the second look by a different person, I think, is a best practice.
even if I could get an evidentiary hearing from that determination saying, no, I don't get the visa, I should have another.
There's no evidentiary hearing at any point. It's all, the investigator looks at your application, looks at your arguments and says no. But I think there should then be an opportunity to ask a higher level, like a superior officer in the consulate, to take a second look. That is the way they do it for visas.
And should that be true if there is, outside of the visa context, an evidentiary hearing that's already permitted by the agency? I think that's what I'm getting at. How many steps are we creating in paragraphs 11 and 12?
Well, it is a second step, but there are no evidentiary hearings at any step.
Jeremy?
I think there might be different uses of type A, type B, and type C. I think what we're talking about here, Michael, right? Like, okay, I come from Social Security world where you have a very informal determination, then there's an ALJ hearing, and then you go to the appeals council, which is non-ALJ adjudicators. You wouldn't think of that as type C, then appealing to type A, then appealing to type B. You would think of that entire system, all stages, as type A, because there's an evidentiary hearing in that process by an ALJ.
Correct.
When you're talking about type C, you're talking about only those programs in which there is nothing like the immigration courts, nothing like an ALJ hearing.
Correct.
Okay.
Is it the word decision that's throwing us off here, that we're kind of, we bring our baggage of what that means? I almost feel like this is, and when you're talking about an application for a visa, that the decision maker hasn't quite made their decision yet, right? So it's not even a proposed decision. I'm looking at your application and you should have an opportunity to augment it or supplement it, or cure it if there's something missing, or, before I stamp this rejected,
That's
will
right.
be my decision. Once we start talking about time and detail to challenge that decision, I hear something like 12, right? That's what in my mind, I'm hearing that. But that's not the process being contemplated. I'm not sure quite how we capture this. I want to say before the decision maker issues an appealable decision, which is obviously not what we want to say, but conceptually, that's the way I'm thinking about it.
I mean, I think 11 is okay.
With proposed?
Yeah.
Aye.
So I think we should keep 11 as is, and then we should just do maybe a little self-education to get ourselves in the same place, Michael, where you are, where you've been delving into it, to not feel like this is going to be a huge shift for agencies that are doing type, like it's not going to be that big of a deal for the employee. I'm almost thinking, of the agency's proposed, right? It's, furnish notice of the employees, agency employees, don't change it. I'm just saying conceptually, proposed decision. And let's just, as I said, let's just do a little self-education to make sure that this doesn't seem like it's going to be a huge, little shift, because you're not thinking it
No,
is.
it's definitely not. So let's think about fish inspections. Okay.
Right.
You're importing fish, and somebody from the department does an inspection and the fish isn't so good. Needs to tell you, hey, my inspection shows this fish is tainted, and you need to, so that you have a chance to say, no, it's not. So your test is invalid. Your machine is not working, whatever it is. Okay. But the fish inspector has ruled that the fish should be destroyed. So 12 says, well, after that ruling, you should be able to go to the inspector superior and get a second look. Well, they're two distinct ideas, and I think the second look idea is very common in adjudication, but sometimes things are so trivial that you wouldn't do it. You'd say of the forest ranger who says, Michael, you get the campsite, and Kai, you don't. Well, we're not going to have an administrative review of that one. You should have an opportunity to say, but wait, I got here first. Okay. But once you've said that and the ranger says, Michael gets it, there doesn't need to be an opportunity to go to his supervisor and appeal. It's just too trivial. But if it's more consequential and there isn't a huge time problem, you should have a chance, I think, as a best practice, to go to the superior, to the decision maker superior for a second look. I don't think that's a radical change.
No, that's not. I think there's no question or lack of understanding that 11 and 12 are different.
Yeah, that's
and
right.
then in 12, you have correctly limited by saying, unless it's impracticable because of high caseload, low stakes, which would be the campground, lack of available staff or time constraints. So that's 12. But that's good about the campsite one. So what you're saying is, before that forest ranger gives it to you and not to me, right? That forest ranger tells me, by the way, you're not going to get it. And that allows me to, using Nadine's word, cure the problem if you didn't realize I was there before. So I was always just focused on 11, like maybe the forest ranger has not been used to telling me I'm not going to get it. And you're recommending that, I mean, ACUS would be recommending, you know what, you may not have thought to do that, but we're saying as a best practice, we don't care how low the stakes are, you know, tell the person who's not going to get the campsite, you know, which, as I said before, as a matter of fairness, I'm actually all about it. You know, that sounds fine. And in most cases, it'll be like the fish inspector, you know, which is, hey, I'm about, that makes sense to me as opposed to the campsite. It is really important to say, I'm about to say all your fish should be, you know, taken out. So I guess what I'm saying at the end is, let's leave 11 as is. I think people will get it, that 11 is about curing a problem before final decision. And 12 is about getting to go up the chain, and you should always get the chance at 11. You may or may not get the chance at 12.
Correct. That's right.
So Nadine, I would stay with it. I still would want us to do our own self-education in terms of being able
Yeah,
to.
I, you know, we can put a pin in it, but I actually, I'll go to Kent in a second. I actually, Michael, what you said about the opportunity to submit evidence and argument, which is where we started the recommendation. I'm starting to wonder if this really has a place there, that, you know, that opportunity needs to come before that decision maker.
Yes, I agree with that, Nadine. I think we should rearrange the order.
Signs it, you know,
The
and
notice
says,
should come before the opportunity.
yeah, I mean, you're really talking about giving the applicant or the party an opportunity to be heard.
Right.
Before, and they need to know where this is heading, right? This fish is bad. No, it's not bad. They need to have that exchange before the inspector says, nope, fish is bad. Done. I'm signing it or stamping it. And now you have the review process in 12. But anyway, Kent.
First, this colloquy has just been very helpful. Just hearing Michael and I going back and forth, and Jeremy's interjection about the differences of how to think about the types of adjudications. I would add just one thing, kind of springboarding off Nadine, what you just said, is right now, I know we just have a placeholder for notice that's sitting there. I think I would make notice an opportunity to be heard. I think that helps clarify what it is we're trying to do at that cure step. Does that make sense? And so then we understand administrative review is different.
I think they should be kept separate, Ken. I've got to tell you what's the problem with your fish, and then you have an opportunity to protest our separate ideas.
I really do think it might be something that fits under at the start.
Yeah, but I would move it up
opportunity.
in the order. Yes.
Yeah, I mean, the heading for, opening the recommendation is opportunity to submit evidence and argument. And we want to be sure that the person has that opportunity before any, I don't want to say final decision because I know that's a loaded term, but Jeff, clarity, Jeff.
Hi, I'm sorry, I missed previous 10 paragraphs. But so far, the discussion on this one has all been on the first sentence. What about the second sentence? The notice should provide access to materials in the agency's file as needed. We don't want that to become some kind of a delaying tactic or, supplement to FOIA or something. I mean, is it a separate issue? I mean, I guess I'd like to hear Michael talk about how this might work in some of these more trivial type C adjudications.
Yeah, it certainly doesn't apply to the more trivial ones, but some of these are much bigger. And
Right,
there is a relevant file.
So have we done anything in the foregoing part of the recommendation to sort of explain that we're not talking about the most trivial type C adjudications?
No, you're right that we're talking here about pretty non-trivial ones where there is a file and you need access to it. I mean, that's not going to be true in the case of visas. So
it seems like
maybe you should add on, under appropriate circumstances or something like that.
Yeah, I mean, it seems like the first sentence, based on your explanation, might apply to all type C adjudications, but the second sentence needs to be.
I agree.
Well, why don't we? I think Hai suggested this earlier as well. We maybe think a little more about 11 and 12 and how we want to sort out where it fits in the best way. These are important concepts to capture, clearly. It's just a question of how we convey it. And I am fully aware, as Hai said, we don't want to make it sound like we're adding a step or adding something that an agency is going to say, wait a minute, I don't want it to do, what are you talking about? I say the fish is bad, the fish is bad. There's no other step here. So why don't we put a pin in this, as the kids say, and we'll kind of revisit it. Maybe Matt and Jeremy can do some thinking as well.
Yeah, Nadine, we really have to look at 18 at this point, which goes into a lot more detail about the notice.
Well, it's notice and access, yeah. So they would go hand in hand, yeah.
Yeah, they do.
Yeah. And I'm still thinking it might need to come up earlier.
Yeah, I think it definitely should come up earlier, yes, before the opportunity to object.
Okay. Okay. Why don't we take a 5-minute, no, 10-minute, 8-minute, 10-minute break? And then we can tackle ombuds. I'm hopeful that this will go a little faster. We're kind of
I think we probably should get 18 in here maybe before or after the break, because it's part of notice. Somehow it got separated.
Let me look at 18 quickly. Let's take a quick break and we'll deal with it when we get back. How about that? Before we tackle ombuds. What time is it? See you in 8 minutes. Let's try for 8.
Hey, Matthew, can you put the first couple pages of the recommendation on the screen so I can see what happened to them? Nothing, not too much in one. Okay.
Yeah, Jeff, we mostly just jumped right past your broad comments in our discussion, so we can come back to them now that you're here.
Okay.
There was some discussion, but no resolution necessarily.
Okay. I'm glad you took out is inquisitorial in nature.
Yeah, we took that out a couple places. Also 9.
Any changes in the preamble?
We haven't done the preamble yet.
Haven't done the preamble. Okay. Thanks.
Sure thing.
Have you talked? Oh. mm.
Okay, why don't we get started? I feel like I don't remember what time it was when we broke, but so I think the thought was yeah, to look at 18 to the extent that that links up with this notice, this idea of notice. And so again, the heading is broader than it seems to be contemplating something broader here. But as
Right,
I
and
think
as-
Mike, yeah.
As I'm
really
as I'm looking
discussed.
at 18, Nadine, I think maybe it should all come out.
That's a scary notion. Okay. It's a drastic notion, not a scary notion. But,
You know, because as people were saying before, you don't want to scare people here. And
well,
so I think maybe the first sentence of 18 could become part of 11. But all the other details about notice is probably too prescriptive for such a broad, field as C adjudication.
any reactions to that thought? Hi, I knew you would have a reaction.
Yes. Actually, Michael, I think this reflects a lot of really good thinking on your part and on the part, Jeremy, Matthew, others in making into recommendation. So I actually think that, to the opposite of feeling scary, this sort of, this tells you, hey, you should give the procedural details by which the agency's preliminary decision can be challenged and later appealed. So to me, this definitely indicates, just based on all your work, you definitely think that there should be a preliminary decision communicated to the folks who are involved in these procedures, and they should be told the procedural details and how they can challenge a preliminary decision. That would be our current 11. The details on how they can later appeal a final decision. You're letting them say you should let people know the means that you're going to use to publicize notice. Whether the recipient has a second chance. So I wouldn't worry about this as scaring agencies. I think you're giving them good detail. The only thing I was afraid about the scaring was the assumption in little 2, procedural details by which the agency's preliminary decision can be challenged, is that there always will be a preliminary decision. But I feel like so much of this work is important for the agencies. And so if in fact we all, as I said, through the self-education, feel comfortable that in every type of type C adjudication system, we should have that little 2, that is a preliminary decision can be challenged, then I think we go with it. I do think you're right in terms of, if we're going to have something called notice, you want 11 and 18 to go together.
Yes,
and then you can have
that's
a
very
review, and that's a different heading. So that's what I would say. I don't think you need to off of this.
We do have our favorite hedge here, high as applicable. Well, one of our favorite hedges.
I know, which may not be a bad way.
Yeah, I mean, it's here. Any such document should explain it as applicable. I mean, to the extent that there's concern about whether all type C adjudications result in a preliminary decision. And maybe that's something we should think about for the purposes of the other paragraph.
Exactly. Then the question is, does that go up to 11 as well?
Yeah.
Sets the expectation, or yes, whether that goes up to 11 as well.
Yeah. Jeff, did you have something?
Yeah, since I raised this issue in my comments, I guess I'm one of the ones who was a little concerned about scaring the agencies or putting them off, because I just have sort of a visceral reaction. And I know we ACUS issues a lot of pretty detailed recommendations, but I can just, maybe we should hear from some of our other agency representatives on this Zoom call, but I envision some of our member agencies saying, do you see what ACUS has just recommended? All the things, this laundry list of things that they want us to do for our for all informal or non-formal or type B and type C adjudications. I mean, you know, we can't do all this. Let's just shelve this recommendation. I'm a little afraid of that, and I don't have any problems with the parts, 1 through 8 and in the notice in number 18. I mean, they're all reasonable subparts, but I'm just kind of concerned more about almost the optics of it all. And, if we can, the value of this recommendation, I think, for the agencies is going to say, you need to think more about how you handle your less formal adjudications here. And here's some good practical suggestions, but I think we should look to cut it where we can and keep it as general as we can. And I'm not one to usually say that about most ACUS's recommendations. I certainly, wouldn't want to undercut the committee or the work of the consultant here at all, but I think it's excellent. I just more worried about the reaction from our agency members.
Any reaction here to that? I do think it was something I said at the start, that the line that stuck out for me was that we're really talking about true informal adjudication. I think that was Michael's language. And whether, that means true informal, and then we're creating some formality here that I guess Jeff is raising a concern about. How far do we push in that direction? These are broader concepts to think about.
Maybe we need a type D adjudication, Mike.
Important type Cs.
Yeah, higher stakes.
Yeah, no, let's
not trivial. Yeah, no.
I mean, I think the first sentence of 18, which just says the reg should explain how notice will be provided, is okay. But I think maybe going that all the detail of little 1 to little 8 is probably maybe too much specificity.
And the agencies can read the report too.
Of course.
Well, I don't know if you read the report, but it's certainly true that you can, again, I'm always say something like FAQs or something that you can say, here are things that, you should think about in terms of, our recommendation won't be number 18 anymore, but explain how notice, well, if you're going to then have to say, detail how notice, you're not saying notice of what anymore. Explain in detail how notice and access to material will be provided, because you're basically saying how notice to of a agency's preliminary decision, right? Because don't you get notice of the final decision because you get the final decision? Notice of the agency's preliminary decision and access to material will be provided. So I think it's fine to take out all the rest of the detail and, put it in somewhere else. But Jeff, it's so interesting, I almost split in terms of what you and I, let's say, will sometimes feel. I'm just going back to that, not on the big stuff, and not on sometimes some of the, what doesn't seem like little stuff on the fish. That's a big thing for someone's business. My concern in terms of agency reaction is I just want us to feel really comfortable that in these informal type C adjudications with big consequences, like whether your business is going to not get the license, or small consequences like you don't get the campsite, that we are comfortable saying, before you make that final decision, you got to let the person know. I just want us to feel comfortable in saying that. And you know what, to be honest, it's a recommendation, right? I mean, we don't even have to necessarily say as applicable. We're trying to convey a fairness point. And if in 20% of the cases, that fairness point doesn't really make sense, given how trivial it is, then they won't do it. And maybe that's what we take as sort of comfort.
I'll just add that I wondered if there are maybe a couple things out of this list. I get how a list like this could be daunting, you know, in a setting that might not warrant all of it, but whether there are certain concepts here that we might want to, you know, in a second sentence of some sort, I'd have to think about language, but, you know, making it clear to an applicant or a party that they can obtain this information in another language if they need it. I mean, maybe that goes without saying. I don't know if it does. You know, that certain considerations should be thought about.
Do we need in detail? Should explain.
Just should explain. You know, I guess I'm thinking plain language, which I think we've said in another spot here. Other languages. The second chance language is an interesting thought as well. Deadlines, you know, we kind of, anyone dealing with the IRS knows about a deadline, right? We all deal with the IRS. I mean, there might be concepts here we could pluck out. That's all I'm saying. I'm not sure ditching it all is the idea either. So I'll make a pitch for that. Any other thoughts? We could, again, put a pin in this and allow Matt and Jeremy to think about it. We can all think about it. I do think we're all on the same page, though, in terms of this concept goes along with the other 11. Got 11. I still maintain that we may be really talking about 1 and 2 and how that all flows together in terms of this process. And then at the very end is where you're going to get your stamp, you're going to get your final piece of paper, and then we have a review process possibly. But representation, I guess could cover both the initial, I'm not to say initial, proposed. This is what I plan to do. I'm rejecting your fish.
Because it's tainted with mercury.
Right. Well, no, I can tell you, listen to me. There's no mercury here. Let me show you why. And you know, we can have an exchange and a dialogue there.
That's right.
I should be allowed to have representation from a family member. I should be allowed to look at whatever information you have. Maybe you had it tested by a lab. I want to see the lab because I have my own lab. I don't know. I just feel like now are we getting close to an evidentiary hearing, but you know, we're starting to add some meat to this, but all of it to me is about due process and fairness, right? I want to be sure that I was heard. Isn't that really all anybody in this situation wants? Is to know that they were heard?
That's right. Yeah, but you know, you have to give somebody notice before they can know how to protest.
Before it's too late. Yeah. Yeah. Okay.
So I my feeling now is that you should just take the first sentence of 18 and add it to 11 without getting into all the detail of what the notice should look like, what has to be contained.
Well, we'll look at that. I think this is going to be the biggest changes that we'll consider next time around. Okay. We can move on to ombuds then. Let's try to get through that. Okay. So I think, Michael, you alluded to this comment from Joe Solomon about the SBA and that this was something that you were unaware of.
Yeah, I'm going to certainly add it to the report. It's a great example. I don't
Yeah.
think it needs to be in the
No.
recommendation
Yeah.
though.
Yeah, great. Okay, so we've covered that. Matt. Is Matt available? I guess it speaks for itself about whether we
I'm
should.
here. I think it largely speaks
Yeah.
to itself. I mean, I guess my concern here is the ombuds recommendation was, I mean, to call it the negotiations protracted would be an understatement. And I would just sort of caution that if anything is reopening, changing, modifying anything in the recommendation, that would sort of caution some counsel here, care here. But I don't know that recommendation well enough at this point. I'm happy to look at it to know whether that's the case.
Right. Well, I'm sure it can be made consistent with the previous recommendations.
We don't want to touch on any landmines here. Thank you, Matt. So there's some wordsmithing here. I think we took out the he, she. I think that was Russell who recommended that. So thank you to Russell for that. We definitely want to do that. And then there was the should consider sharing. Now, I don't know if Andy's still on, but I know we're trying to get away from the should consider. Any reaction to that change?
I'm still here, Nadine. Yeah, I have been trying to make the agency be a little bit more certain about what it thinks, and whenever possible, change the softer should consider to should. And it came up because we've considered it, and now we think they should. And it came up somehow at the last plenary, and we talked about it a little bit. And we didn't formally vote, but I think everybody who voiced an opinion was in support of that. So I feel like I've got the assembly behind this as well. Thank you, Nadine.
Yeah, of course. Any thoughts,
Yes,
Jeff?
you're talking about 18, right?
Correct.
It's a little ambiguous. I mean, were we saying that smaller agencies should consider sharing a particular ombuds that's out there? Are we just saying that agencies should, like sort of agencies with similar responsibilities should combine? And I don't know if I don't know if this is one that we should take out, consider, because if I was a small agency and I didn't want to share an ombudsman with it, I mean, some agencies might not go together. You know, I don't know if, I don't know if ACUS would want to share an ombudsman with the, Defense Nuclear Board or something like that. So I think this is drafting matter at this point, but
Renee, you have a thought on this?
Yes, smaller agencies may wish to consider sharing a
ombuds with other agencies.
right.
Well, I say just may wish to share.
Yeah.
I don't think you need to consider.
Yeah, I agree.
Mm.
Is that a recommendation?
Andy? Oh, you're muted.
There's a different way to do it here. Responding to Jeff, we're not saying must, that they must do it. We're saying because we believe that they should. So, that's different than must. We're not forcing them to do anything. And I think wish to is even softer than should consider. But whatever the committee thinks.
Thank you. Russell?
I don't think it seems almost silly, pardon me, not silly, but very strange to give agencies to countenance their ability to wish for something I would beef it up from that. And maybe if it's perhaps just add the kind of example that Jeff was talking about, rephrase it in a different way so that we recognize that some of these mergers aren't going to be very profitable, but the others will. You could just tag a phrase onto that. Agencies, agencies may share a single occupant, especially when they have missions in common or something like that.
Jeremy, did you put your hand down?
Same
Never mind.
thought. So my hand went down.
Okay. So any thoughts about should versus may wish to? Should we just say should?
I'm in
Hi.
favor.
Yeah, I definitely don't like the may wish to, because that does sound odd, right?
I don't think we need single either.
Right, to share an ombuds, program. Agencies should consider sharing an ombuds program if necessitated by resource constraints. I mean, my main issue looking at 14, 15, 16 is, this is not necessarily going to be a high priority for an agency. I think it's, again, and on the fairness piece, totally makes sense. But an ombuds is really just a whole another level. And again, I think here it's almost that we want to, in conveying this to agencies, explain things that we think are really a minimal minimal expectation if you're going to do these adjudications, and then a best practice. I mean, that's only the way this is in discrimination issues and employers. If you can afford it, it's really good to have an ombuds. But I still think it's fine to say agencies should establish a program that empowers an ombuds to do it. And then just, again, in implementation, say, we recognize for some of you, that's just not going to be where you're going to spend your limited resources. I do think 18 is a nod towards, and I don't even think you need to say small agencies. I mean, agencies should consider sharing a single ombuds to address resource constraints. I don't know, I don't know that we have to say, especially when they have missions in common, sort of like you said, they're not going to reach out to an agency that's completely out of their area. I feel like 18 is our way of saying we recognize resource constraints. We're not going to say, as we sometimes do right up in 14, taking into consideration resource constraints, agencies should establish a program, because I always feel like we don't need to say that. That's going to be a reality. So I want us to be realistic, but I also don't want us to pull any punches in terms of what we think is the best practice. So I would keep 14, 15, 16, 17, and then 18, I would take out, especially when they have missions in common. And to be honest, would take out the word smaller.
And I think Jeff, you were advocating for sharing an ombuds program.
Yes, sharing an ombuds program, because sharing already indicates that.
Renee.
So, I mean, I understand why people don't like may wish, but I just think I think should consider, because it is odd. I think the should is odd in this context, because this isn't one of these things that we're telling them this is what they really should do. It's just sort of highlighting it as an option in case they don't think of it themselves, right? So that's why I don't like the should, because it seems a little bit more mandatory. on the sharing. And I think the share, having the program should is a good word, but on the sharing, I think it's a little prescriptive, unnecessarily prescriptive. And that's going to be the last you'll hear from me because I have to go to a meeting now. I'm sorry.
Thanks for joining us. We'll see you next time, I hope.
Right.
See you, Renee.
Bye.
Kent, you have a solution.
No, unfortunately, I've got another question. As people have kept talking, I think I may have misunderstood this recommendation a bit. I thought what we were doing was primarily suggesting in what is now paragraph 14 that agencies should include within the things that an existing ombudsman could hear type C adjudications. As we keep talking through this, it sounds like we're saying, let's set up a whole ombuds program. I mean, I'll let Hai and others at the agency speak to that, but when I realize that's what I think people are saying, that strikes me as deeply concerning if I work at an agency, because we've just said that type C runs the gamut from extremely trivial to something that's very significant. An ombuds program is quite expensive to put into place, and you've got to create this whole apparatus around it, including what kind of powers they have, all of these natures surrounding the jurisdiction, I guess, of these type C programs. And I can't tell if they're only doing the type C programs. Why are we recommending something so significant? I mean, if anything, I would have thought just that paragraph 14 saying, if you have an ombuds person, then allow them to hear concerns about type C adjudications is more than sufficient. But I may be alone in all this because I didn't realize what it was suggesting until we discussed it.
On this point, look at recommendation 5. An agency office dedicated to helping the public navigate agency processes.
Yeah,
that sounds like an ombuds.
We did discuss this earlier. And it is intended to address a broader concept. Well, maybe it's not a broader concept than just an ombuds program. It would be specifically, like I was saying, I'd like to think every agency is helping the public navigate their process. That this is a dedicate, not necessarily a, something that would be within only the purview of the ombuds program or part of an ombuds program. It would be an actual, if you need help, you can contact Joe, who works in this office, and they'll help you navigate. This is what you need to file. This is the rule you need to look at. That this was not just limited to that.
So
I think
to Kent's point, though, it seems like we are suggesting that that agencies that do type C adjudication have such an office in recommendation 5. And then later in the ombuds section, I mean, we're suggesting a whole list of recommendations.
Yeah.
I mean, why don't we just add something to number 5 that says something like, or use existing ombuds to do this?
Well, Jeff, it's a different concept. I mean, I saw the one of them is simply to help people navigate complex bureaucratic structures. That's nice to do. The ombuds is to receive complaints. And I saw it as being a substitute for evidentiary hearings. In type C adjudication, you can really feel like you're getting a fast shuffle and you're out. And people are, it's often people are uncivil and rude to you, and just have a variety of it's for complaints, and it's a very useful structure. So it sounds like it's kind of a substitute for evidentiary hearings in a way.
I take your point, but it sounds like the recommendation 14 then is taking another step to say to an agency, if you don't have an ombuds, but you do have type C adjudications, you should establish an ombuds.
Yeah, I am saying that.
Which is, I think, what Ken's point was, that the language in 14, I think, makes it sound like
Yeah, if you don't have,
Your
the
ombuds
ombuds
program
can cover
yeah.
lots and lots of things the agency does besides adjudication.
Yeah.
But I think it's something that's pretty useful in conjunction with a system of type C adjudication to give people, they don't get a hearing, but they can complain. Now, if the agency can't afford it, then they won't do it. But I think it's a best practice. Just like the ability to get the second look is something that's really useful substitute for the lack of an evidentiary hearing, and I think this is as well.
So in a way, this is a supplementation to the 2016 recommendation, essentially saying, to an agency, you may not have an ombudsman, but if you have type C, you should create one.
Yeah, that's right.
So then that raises Matt's point about, we're going farther than 2016, but we're not really explaining that. Maybe it can be explained in the preamble, but it's departing. Well, I guess I better look at 2016.
Yeah, and we have a note there. Matt has a note there that we're going to check that. Hi. You're muted.
By the way, 2016 says agencies should consider creating additional ombuds offices.
Oh, okay. So that's consistent with that.
Hi.
It's different, right? Because instead of saying agencies should consider establishing a program that empowers an ombuds, we're saying in terms of, and I think this is fine, in terms of a best practice, right? Here's our recommendations. If you have type C adjudications, which means by definition, there will not be an evidentiary hearing, okay? And we're not saying you should have an evidentiary hearing, but we are putting in some pieces of that. Notice of the preliminary decision and an opportunity to push back, provide new information. Depending on significance and ability to go to someone else. And now this is the third level of protection, because look, we're saying that ombuds person can actually mediate between the agency and the private parties. That's an interesting new thing, right? Recommend that the matter be reconsidered by a different decision maker or a new appellate reviewer. That's a big deal to do, right? If they are going to consider improvements, make sure they have a way to advocate for such changes. So I just feel like a lot of these are ideas that have come out of, Michael, your work on seeing how consequential some of these decisions are, and they don't have an evidentiary hearing. So I actually think it is fine to keep this all in. But again, in the preamble, that is precisely, Jeff, where I think it should go, is to say, as a best practice, we think if you are going to have these type C adjudications, you should have an ombuds person. And again, say right there, we recognize that this is a resource issue, recognize that it might not be the highest priority. I wouldn't say that in the preamble, but somehow to sort of say, obviously that's a decision by the agency, but given our report, that is the report that you've done, we think this is a good practice.
Any other thoughts?
And therefore, the last 18 is the one that well, this is just to repeat what I said before. 18 is like our nod to the resource issue,
right?
Which I think is fine.
Is it clear? I think I'm going back to Ken's concern that we are actually saying we want agencies to establish a program as opposed to do something to an existing program. Is there language there, Kent, that's not conveying that?
Yeah, we think they should establish one.
Yeah.
If they don't have one.
Yeah. Thank you, Nadine, because I didn't even read it at all that it should have your current one if you have one, but definitely a completely new thing. So if there's any language to make that clear, sure. It just wasn't something how I read it, so.
Yeah,
I can't find anything in the ACUS recommendation 2016 that talks about mediation or recommending that the matter be reconsidered. So it seems like when you try to meet Matt's point, if you it may be going, this may be going farther than the conference is willing to go in 2016, which might be okay, which might be fine, but it's,
yeah,
I
in
think
this context.
we need to recognize it. Yeah.
Yeah, it might be too prescriptive in the form that it is now. Maybe we don't need to spell out all the stuff about mediation and all.
Yeah, language or,
Well, I'm not sure if I do have better language at this
Okay.
point, but one question, maybe, again, I'm trying to make sure I understand what we're suggesting. If there were an existing ombuds program, is this recommendation okay with allowing the type C adjudication complaints to go to that existing ombuds person? Or are we saying there needs to be a separate ombuds person for this?
good question.
No, of course, if the
No.
agency already has one, that person should have jurisdiction over the type Cs. But
Yeah,
if they don't have one, they need one.
I may just differ from where everybody else is on the committee. I'm okay saying that an existing ombuds person should have jurisdiction over the type C adjudications. To my mind, it's a bridge too far to say you need to create an entire ombuds program if you have type C adjudications, because they're so widespread and they are just, they're going to be in all of these agencies. To me, we're asking for a lot of those agencies to set up these programs, even if they're sharing one, to coordinate with each other on that, to essentially just have a bureau of complaints after we've said they should have the ability to cure and to have another level of kind of appellate review within the agency on it. I just think it's too much. But you know, I may be the lone voice on that.
I don't think you are, Ken. I mean, does ACUS have type C adjudication? Does ACUS need an ombudsman?
Chris,
Oh, sorry, Chris.
Chris,
Yeah, I mean, this goes back to somewhat of my original framing question, which is, it's probably too late to even go down this route, but again, I think of it similar to Emily Bremer in the sense that the default is actually an evidentiary hearing, and when Congress decides not to have an evidentiary hearing, then we think about what can we do to ensure that those type C adjudications where there's not going to be an evidentiary hearing are fair and consistent and the like. And so I think, like, in my mind, the whole recommendation is like, we're already assuming like the best practice would be to have an evidentiary hearing, but Congress decided for a number of policy reasons this is low stakes or other reasons why they don't want that hearing. And in that sense, I do think an ombuds program fits in as like a potential thing for them to think about. But I'm still kind of stuck on this. I would want the recommendation to start with saying that like the default is an evidentiary hearing, and we only get here because Congress has decided not to have one.
hi.
Well, just in that last point, I think just because Congress may not have decided to do it, I think we would all agree that fairness might still require that there's more. And anyway, you're saying that the default, if possible, should be evidentiary. But I think back onto Ken's point, I think maybe the way to do this is for 14 to say, if an agency has an ombuds program, the ombuds should be empowered to receive and investigate complaints, and otherwise agencies, and maybe there it's okay to say should consider establishing a program. I mean, I understand that needs to be wordsmiths because it's redundant, but I certainly think, to Ken's point, if they already have an ombuds, and I've never been in an agency that has an ombuds program, so I want to acknowledge I don't know how that works in an agency. So should be empowered. Well, I don't know that it's such a program, because then it sounds like a general ombuds program in which they're also doing it. So, you know, so certainly if they have one already, why not give that person the power? And by the way, it may not be a whole program. But again, just also going back to the last piece of not demanding too much of agencies. Again, I'm usually the one that's sort of saying don't demand too much. And here I feel that one of the things ACUS does is come up with best practices, something to aspire to. And in that case, I think this is a good aspiration.
Wouldn't it apply to all adjudications? Investigate complaints about it, agency adjudications, including type C adjudication?
Yeah, but this is a recommendation
I know.
on type
We're only
C.
talking about type C in this recommendation, but it seems a little odd to say that they should just consider it only type C.
But think about this as ACUS thinking about ombuds in this smaller context, and then maybe you have it in the larger. Again, I just keep coming back, Michael, to your point of this is, you know, situations where there is not an evidentiary hearing, which we believe, for matter of fairness, is probably the best default, but sometimes Congress hasn't set it up that way.
Any other thoughts?
Otherwise agencies should consider establishing such a program. Period.
But my concern about that, when it was there before, is doesn't it sound then, Jeff, that they should consider setting up a broad ombuds program in which a subpart is to receive and investigate. And here we're saying
for that purpose.
For
Such a program for that purpose.
Because there isn't an evidentiary
for
hearing.
that purpose. Yeah.
No, but don't set up, no, what you have there is not, at least where my position would be, which is if you have one, obviously let them adjudicate this. If you don't have one at all, you never consider doing one. And most of what you do is evidentiary hearings. You know what? Now, if you also do type C, this is a moment to have a program that empowers an ombuds to receive and investigate complaints about those types of adjudications and really sort of make that clear why we think it's a best practice, even if you don't otherwise have an ombuds program. Again, do I think most agencies will do this? Probably not. But should that be the basis on which?
It's almost like you're implying that there's more need for an ombuds program when an agency has only type C rather than type A.
I think that's what Michael's point is, no?
His point.
Yeah, so, you know, if agencies have an ombudsman already, I'm sure that the ombudsman's jurisdiction would extend to type C. And the ombudsman do all kinds of things that don't even involve adjudication. Everything the agency does that affects the public. An ombudsman generally can look into. So I don't think we need to address the question of existing ombuds programs, but this is, I think that an ombuds program is really useful in an agency that's conducting type C adjudication to give people who are enmeshed in a sense of fairness. I mean, in the report, I have a lot of stuff about the sociological studies about what people find to be acceptably fair. And it's really helpful to have a place to just complain. They treated me badly. They were rude and unpleasant, or they didn't pay any attention to my evidentiary presentation, or all the different things that the feelings of outrage people have when they feel they've been dealt with badly. That's what an ombudsman does, and it's a good substitute for an evidentiary hearing. It may well be that agencies aren't going to do it, but it's still, I think it should be a best practice. Just like the second look should be a best practice.
So you want to go back to the original, just the second
Yeah.
sentence?
Yeah, I think this that they should establish one if they don't already have it. Yes.
Yeah, and
I-
by the way, I'm fine, I'm sorry, I'm fine with that. And then I think you can make your point, Kent, to your question of, I wasn't sure what this was. And when I was like, I thought it was clear. We can choose to put that sentence in the preamble so other people realize when they come to this, it is agencies should establish. That is the best practice. And, you know?
Yeah, and I think it has to, I mean, if we're gonna go this route to address Kent's concern, in terms of the confusion about what this was really doing. If this is the path we're gonna take, then I think it should say agencies should establish an ombuds program that empowers the ombuds too. So that it's clear, like if that's the path that we're gonna recommend, it's very clear. I think Michael's point, if I heard you right, which is that an agency that already has such a program certainly covers this already.
Sure.
Yeah. Janice?
I just want to put a vote in favor of Ken's position and the previous edits that we just took out. I feel pretty strongly about that.
Thank you.
This is aspirational, but just want to make that point.
Yep. Any other comments on this? Is this something to revisit next time? I mean, I think there's enough considerations here that if we are gonna take that path, whether we need all of this.
Well, I mean, I think there's a case to be made that we don't need 15, 16, and 17 because the 2016 recommendation covered everything that ombudsman
Much of this, yeah.
should do and be.
I think that's right. I think this one has gotten too prescriptive.
And I would just suggest on the 14, well, I'll let Matt type and then I'll suggest. Go ahead. Type.
2016-5.
I think it's in Matt's comment. We don't have it. I was just gonna suggest some language on 14. It's a little wordsmithing, but agencies with an ombuds program should ensure that. The ombuds is empowered too. And again, I recognize fully that Michael's point is that agencies that have this program likely, certainly have an ombuds that's empowered to do this.
Right.
Yeah.
So I don't think you really need to.
You don't
say
think it's
that.
necessary?
No.
But it's not harmful.
No, it isn't harmful. But the important point is that agencies that don't have them should have one.
Okay, and then the second sentence would be, yeah, if you should consider, I mean, it's either going to be, this is our big debate here, I guess, for the committee to think about. Do we want, we've heard from both sides, I think, on this. Do we want to say that they should establish it, they should consider establishing one, those that don't have it?
Well, I think if they only have a few type C adjudications every year, then they don't need to establish one.
Is this where we have, don't we have language somewhere where we say depending on stakes, caseload? There's some hedging language somewhere in here that I can't remember where we have it. Oh, it was 12.
Well, that's fine.
Unless it is impractical because of high caseload, low stakes, lack of available staff.
If practical or practicable, language of that sort is fine.
I mean, technically, ACUS makes type C adjudications, right? When ACUS rejects or bids to do a project, that's a type C adjudication, isn't it, Mike?
Yep.
So doesn't happen that often, but I don't think ACUS really needs an ombudsman.
I mean, ACUS adjudicates all the time. I mean, I think FOIA is type C under Michael's typology, isn't it?
Yeah,
But that would
well,
make every
absolutely,
agency-
that's right.
then
A
every
rejection of a
agency-
FOIA request is a type C adjudication.
Every agency would have to have an ombudsman then.
So be it.
I think this will be an issue we need to give some more thought to and consider whether, and we may have hit on something kind of hybrid here, but whether all these details, we would take them out, and I think is the recommendation would be to look at the other 2016-5 and see if there's can point in that direction. Any other thoughts on this? This is really, really productive.
We're
and
leaving
helpful.
consider in, then we don't need the unless clause, right? Because
Correct.
okay, that's the issue.
Oh, well, I if we take consider out, I think this is a point of debate that we need to think about whether we're.
If you take consider out, then you need an unless clause, but.
And I do think I'm hearing the chairman's voice in my head. We want to say should, where we can. Now, whether he's comfortable with the unless hedge, I don't know, but at least we're acknowledging the reality of the situation, which we've done in the other recommendation on the administrative review piece, that there may be some considerations. Andy, yes, please.
Yeah, Nadine, my sort of, I wouldn't say preference, but default that I would argue for should is not without exception. So I think what you worked out in 18, which is now moot, was the right answer and the right exception. In this one, I feel more comfortable with an unless clause, just to keep the momentum of consider going, but again, whatever everyone thinks is best.
Got it.
Why would it be impractical because of a high caseload? High caseload of the ombudsman, you mean?
No, I don't think this is really dependent on caseload.
Yeah.
Well, I thought we were saying that if you have 2 or 3, it wouldn't be
If it was a
high, it would
low
just be because
caseload.
of
Then
caseload. How about
it's
just
a job.
caseload? Take out the modifier, just caseload.
Caseload considerations.
I mean, I think Matt's point was that, you do a few a year.
Well, then you wouldn't have a full-time ombudsman, but we could say, Matt, among your jobs at ACUS is to receive complaints.
Or you could join with another agency.
Or join
Right.
with another agency. But it seems okay to say there should be a place where people can just complain.
So again, just to make sure I'm understanding it, to Michael's point that there should be a place where people can complain. Are we suggesting here that this place where people can complain is to complain about everything or only about type Cs? Or if you're going to establish something, at the very least, it should be about type Cs. If it's something broader that we just think everybody should have an ombuds person, I don't know what that's doing in this recommendation. This just seems too far afield. If it's only that they should have some kind of ombuds person for a type C adjudication, I still think that kind of saying if you've got an ombuds person, yes, they should be able to hear this thing, and maybe they already have jurisdiction over it. I don't know enough about them to know. But would I tell agencies you need to create an ombuds person just for type C adjudications and nothing else? No, I wouldn't do that in numerous cases. And again, if it's broader, you should have an ombuds person to do all the things. I don't think it belongs in this recommendation.
Hi.
So, sort of given the time and given, in a sense, really the complexity of this, I really like the point of putting the pin in this and having us all mull. I think part of what we should look at when we mull is, number one, maybe just sending around the 2016-5, but also, Michael, if there are particular sort of pages in the report where that you think would be helpful to read to get a sense of why you think this is important? Because my gut on fairness is that it is. That would be helpful. And I guess the last thing I would encourage us to mull before we come with what we think is sort of the last thing Michael said. It may not be that you need a whole program, but it may be that someone among their responsibilities is, this is who we tell people to come complain to if they didn't get the contract.
That'd be okay.
Yeah, no, I agree. And therefore can't, and again, let's come back and when we come back to talk about it, there's no way I could agree with the recommendation that as a best practice, every agency should have an ombuds program that deals with everything. I mean, I know maybe that's what the recommendation said, but I definitely think we want to convey to agencies that when they don't have evidentiary hearings, so Kent, it's exactly to the point, when they don't have evidentiary hearings, they really might.
That's right.
They should have something like this. So, but again,
That's all we're saying here.
Right. That if we articulate what are the things we want us all, each of us want to mull before we come back, I think that's probably the best, Nadine, that we can do at this moment.
Yeah, I'm also starting, and maybe it's the lateness of the hour, whether there's a place for this in quality assurance, where we talk about systems to promote accuracy, efficiency, fairness, and the perception of fairness.
Well, it's kind of a distinct idea from that. This is individuals who just feel like they've been screwed over.
Right, but it's a system. It is a system that promotes fairness and the perception. I mean,
well, that's more systemic, and of course, it's something an ombudsman could recommend.
Right,
but it's a distinct idea that they need to take a look at the Type C program in general to see whether it's operating as efficiently and fairly as possible. But an ombudsman is much more about an individual's ability to complain.
It's also related to the one in number 5, helping the public navigate agency processes.
And that's a distinct idea as well.
Ombudsmen do that, though. Ombudsmen do that.
But they could. It could be the same person, but it's a distinct function.
So if we're talking about a complaint handling person, I mean, there are a number of ideas here that could be tied together without necessarily restating so much on ombudsman. And I'm a fan of ombuds in general, but.
well, I also think there's some agencies that, do have mediation resources, to the extent that there's an opportunity for that. Anything further on this topic? Because I think we are almost, I don't know what we have left. I need to look. Anything further? We will obviously consider all of these concepts. I appreciate everybody's candor and appreciate the thoughtfulness that's going into these comments. Okay, so I think 18, we're down to 19, 20. Yeah, okay. I don't know how much let's try getting through at least a couple of these. Let's look at 19. This is almost a little bit of nuts and bolts, but also transparency. I'm not quite sure that forms and deadlines goes with the transparency piece.
Well, again, I think maybe we've gotten too prescriptive on this one. It's just, if you have a system of Type C adjudication, then you should have procedural regulations that explain how it works.
Okay. Any other?
With respect to all of the things that are otherwise covered in these recommendations, such as notice, opportunity for to object, and so on. And, more important is, 20, even though these are procedural regulations, we're suggesting you should use notice and comment to adopt them. And then 21, user-friendly guidance documents. And FAQs and stuff like that. We probably don't need the detail that's now in 19.
Is it possible to just keep that first sentence and get rid of, yeah?
I think that'd be okay.
Kind of overlaps with 20 and 21, or 20 at least.
You combine them, is that what you're saying?
Yeah.
That'd be fine.
I was happy to see Matt raise a point that I had in my notes as well. We've looked at that before, that the cost of doing notice and comment. I always think it's a good idea if you can do it when it's not required, but obviously some agencies have limitations and considerations there. Is it clear what we mean by significant procedural regulations?
You look at 92.1, it kind of spells out ACUS's view on that.
Ken?
If we keep this sentence, I'll offer one very small nitpicky thing. I would get rid of in order before the infinitive. It's just always wordy unless it's between two infinitives.
Thank you. Okay, let's leave that. Let's go to the next one quickly. We've got a few minutes left, and then 21 and 22. This is really about plain language, user-friendly, accessible on the website. This is all good stuff. (22, 21, 22).
I'm not so sure about 22.
Yeah, I was trying to sort out how that would really work.
I think that might be too prescriptive. I mean, it's a nice idea, but I'm not sure that's a best practice.
I had in mind our precedential project that we just did about precedential decisions. So when I saw not precedential, I thought, well, why do we want to tell them about non-precedential decisions?
I mean, this sort of involves you with the question of what FOIA requires, which is a really complex question.
And some types C adjudications don't involve written opinions.
Right.
They don't.
Yep.
But I think 22 probably can come out.
Okay. Our new 22 is quality assurance. There's Kent's in order to. Take out the in order.
Take it out.
But it's also, this has the consider, which is different from as written. And I'm assuming, Michael, you actually think this is a best practice.
Yeah.
So,
It should adopt.
Right, it should adopt.
Right.
And again, let's make sure we all feel comfortable with that. It costs money to have a quality assurance system, but
depends on how extensive it is, right?
Right. And actually, then you can just say should have, which is what you had before. Instead of should adopt, agencies with those should have a quality, and then you just need an A, right? Have a quality. Oh, I see. Should have quality assurance. Oh, I think it should still be, because then it sounds, isn't it just one system? It's a quality assurance system. Which includes
could be more than the systems that we list at the end.
Okay,
Yeah.
okay, should have quality assurance systems.
Any other thoughts here? Okay,
I don't know if you need a quality assurance system for some of these really minor type C
yeah,
adjudications.
I think this goes back to your point you've been making since you
Yeah.
came on, which is, you know, the carve out, like, are we considering the trivial type Cs?
Yeah, can we put a pin in that for when we're discussing back on that point of,
Yeah.
you know, because a quality assurance program might be as much of it's if you got a complaint, you have a basis for looking at what happened, you know what I mean?
Mhm.
And it's the reason I also said back to your point, Nadine, of, well, you know, this ombuds and quality assurance seem to have some connections, which they do, even though, as Michael pointed out, they are also different. So, but
Yeah.
I think that's all sort of grist for the mill.
I will say that 2021-10 does not distinguish between different types of adjudications, but it does use should consider a lot.
Mm. We can double check that. All right, I think we are at 4 exactly. I want to say we got through the recommendation, although we still have several pins to unpin, which we'll have to do next time. Greatly appreciate everybody coming to the table on this. This is really good stuff and really good thoughts about how we can make this work.
And remember
Thank you.
to send me comments on the report.